Greetings, my name is Michael Carroll. I'm a professor at American University Washington College of Law, and I'm going to talk to you about copyright, text, and data mining, an American perspective. This slide deck is based on an article that I've written called Copyright in the Progress of Science, Why Text and Data Mining is Lawful, and all of the citations and supporting materials for what you're about to see can be found in that article at that link. So I want to talk about text and data mining, what it is, fair use as a user's right, fair use and computational uses. So this is the legal background for my argument, identifying two lines of cases that have found that analogous uses are legal under US copyright law. I also want to point out a feature of US copyright law that limits the scope of copyright in the case of temporary or buffer copies. And then I want to make the argument that text and data mining is fair use, primarily under fair use, but also that the limit on the copies that count would limit certain uses of the temporary copies. And my argument extends even to when the source is infringing, such as Sci-Hub, which is clearly infringing copyright in the US, but I still think a researcher could use that as a corpus for text and data mining. And I want to end just talking about how cloud-based text and data mining may not even need fair use and could be legal just because of temporary copying. So why do we care about computational research? Copyright is supposed to promote the progress of science and useful arts, and text and data mining is part of that progress. You can use computational research on published research to understand what we already know. There's information overload, we can't read it all, to aid curiosity-driven research, to identify patterns and other things that would allow us to figure out what our next research question should be. And then also identify new entire lines of research that might be available. So for example, the US government's DARPA, which sits in our Defense Department, but is one of the origins of the internet, has a text and data mining project called Big Machine, and it's really about cancer biology. And so journal articles are ingested, turned into structured text data that can be used, and then it is quote unquote read, fed into a model manager, fed back to the reading stage to create the model sort of based on the testing data to then improve the understanding through the assembly process, feed the revised models into the model manager, and then at the end run this on the testing data in order to get your outcomes, including possible predictions, explanations, etc. So from a copyright law perspective, all of that activity in that graphic involves making copies, and you make copies multiple stages. When you collect and compile the data, when you format it, when you process it in the active memory, even those temporary copies, we have to do copyright analysis on. And then finally, of course, you need to store or archive the data, both to allow for validation and reanalysis or to extend the analysis further. Now, from the perspective of copyright law, we want to know, is this fair use? Because even if those temporary copies don't count, the rest of the copies clearly do and would be infringing without an explanation, and fair use would be that explanation. But it is worth inquiring also about those temporary copies. Now, here, this is slightly controversial within copyright law. Copyright discourse treats fair use as a so-called exception or limitation to the author's exclusive rights. And when you look at fair use in that light, the author's rights are the privileged position, and the user's interest is subsidiary to that. And in some legal systems, such as in Europe, there are doctrines that say that exceptions and limitations need to be interpreted narrowly, precisely because the author's interest is preferred. I don't think that's US copyright law. The US Supreme Court has recognized that the reason copyright protects authors is a means to an end. We want those authors to produce and distribute creative works for the public's benefit. In addition, users have a First Amendment rights to use copyrighted works in their speech. The Supreme Court has recognized this. But rather than having a freestanding free speech law in copyright, the court turns to fair use and the so-called idea-expression dichotomy to protect the user's speech interests. Idea expression means that you can always copy the idea from someone else's work, but not necessarily their expression. So the syllogism is quite simple. If free speech is a user's right, protected by the First Amendment, and fair use protects that free speech right in copyright law, then therefore fair use is a user's right and not simply a exception or limitation that needs to be treated narrowly. Now, with that understanding of what fair use is, in the statute, a court is supposed to look at these four factors: the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the work that was used in relation to the copyrighted work as a whole. It is never a defense that I used 80% of your work, but it only comprises 10% of my work. We always look at what you took in relation to where it came from. And then finally, the effect of this use on the potential market or value of the copyrighted work. So the courts have taken each of those factors and given additional meaning to them. The first factor has become increasingly paramount. Why do you need to use the work? And in particular, is the work quote unquote transformative? Be careful with that word because it's what in law we call a term of art. You do not necessarily have to transform the source work for this to be a transformative use. The definition in the law includes using the work unchanged, but for a new purpose or in a new context. And that's going to be particularly relevant in the case of text and data mining. The court also wants to know whether the use is commercial or non-commercial. That, though, will also come back up in the fourth factor when we look at the effect on the author's economic interests. The second factor rarely plays a role in the actual decision-making. It's really just asking how much authorship is at stake here. Is this a work of fiction with a lot of original content, or is this a database of primarily facts that are not protected by copyright, with perhaps a little originality in the selection and arrangement, i.e. like the column names in an Excel spreadsheet. And then in the third factor, when we ask how much did you use, the real question is in relation to the reason you're using it, is this the right amount? But the courts have first done a quantitative analysis, is this the right amount? And then a qualitative analysis, even if it's small, is it the so-called heart of the work, i.e. the reason the audience valued the work? That second prong came out of when the Nation newspaper copied just 300 words out of Gerald Ford's biography, but those 300 words were the words that explained why he pardoned President Nixon, and that caused Time magazine to cancel its exclusive license to publish that particular 300 words, because that was really what people wanted to buy the book for. So even small amounts can weigh against a fair use if what is taken is the economic heart of what the work is. And then finally, looking at the effect of the use on the potential market or value of the work, the court wants to ask first, is this direct competition with the copyright owner? When that's true, almost never a fair use. And then, in addition, does the use interfere with existing or plausible markets to license the use? And that plausible market is important because a copyright owner could always claim to offer a license for any use and defeat fair use, such as for a parody. And you could say, well, Saturday Night Live should have asked me for permission to make fun of my work. I would have licensed that to them. The courts will disregard licensing markets like that, and instead are really looking at the copyright owner's existing business model and saying, are they already licensing the work for this use, or is it likely that they might enter this market to do so? You can take that complexity and simplify it and really ask, why has the user chosen to use the copyrighted work, and is the amount of use appropriate to communicate to the audience the purpose of using the work? As long as the user has a story about why they're using it that is different than I want to take away the copyright owner's market, either their licensing market or their selling market, then that's likely to be a transformative use, which is likely to be fair, as long as the amount used is appropriate to that purpose and is not excessive, such that, for example, I can't I can use excerpts of a novel for a critical reading textbook without having to get a license to it, but I can't republish the entire novel and then add 3 pages of reading questions and claim that I've suddenly transformed it into a textbook instead of a novel. Now, when we look at that, so that's the four factors that gets sort of boiled down into the 2-step analysis. And when looking at how the courts have applied this fair use test to particular practices, there are 2 types of practice that in particular support the claim that text and data mining is fair use. First, in the 90s, we saw cases involving so-called intermediate copying. This often involved video games or other kinds of operating system software where the defendant wanted to create some interoperable complementary good. So in one case, they wanted to create game cartridges that would play on a Nintendo Nintendo game box. They had to copy this software in the Nintendo box in order to figure out how to write their own game. And the court found that that was a necessary intermediate step to create a non-infringing product. They wanted to copy the work in order to study the non-copyrighted ideas and facts that are in there. And therefore, it was not harming the copyright owner's ultimate market, even if it was creating a competing product. The competing product was not competing based on the author's original expression. And so that has been deemed to be a fair use. Separately, there have been a number of cases where systematic copying by commercial entities has been held to be fair use if the purpose of that copying is to create something like a search service or a search index where you have to do large-scale copying in order to achieve that end, and where the end product does not give the public access to the copyrighted expression. So in the Google Books case, Google copied 14, 15 million books from academic libraries, scanned them all, created a search index, giving users only snippet views of the contents. And the court held, even though Google is a commercial entity, even though that was large-scale copying, it was a transformative use that provides us with this very useful search service on the literature of the 20th century, and it is not competing with the actual markets to either sell or license those books. And in addition, the copies that were left to those academic libraries have been congregated in the HathiTrust, and the HathiTrust was also sued and was also held to be making a fair use. There have been a couple of cases involving image search, and the courts have found that merely copying images for the purpose of creating a search index using thumbnails does not infringe copyright and is a fair use. A company that created a video search service of what politicians and public figures were saying on television news shows also was held to be fair use. And copying students' term papers in order to create plagiarism detection software also has been fair use. In all of these cases, we're creating a large corpus of copyrighted data in order to then engage in computational analysis on that data, and it's always been held to be a fair use. So I do want to just keep this point out there because it may become more important as technology develops. There is a technical definition to the copies that count in US copyright law. And that technical definition requires that the thing that you are saying is an infringing copy has to be capable of being perceived, reproduced, or otherwise communicated for a period of more than transitory duration. So of course, almost anything can these days be otherwise communicated by digital technology. So even a few nanoseconds would meet the first prong of that definition. But the transitory duration says Normally, those little buffer copies are not long enough to count. And in fact, we actually have a case, believe it or not, that tests that question. The court held that a buffer copy lasting only 1.2 seconds was simply transitory and did not count as making a copy under copyright law. So now, applying this law to the case of text and data mining, it's fairly straightforward based on the logic of what's already been done by the courts. The reason a researcher is making copies of science journal articles or the data that underlie them is to extract patterns or other non-copyrightable information from that literature. So that would be a classic transformative use. It's either an intermediate use in the sense that what the final product of the researcher is a non-infringing product. Of course, the researcher needs to keep copies of all of that data for validation and reproducibility reasons or to extend the research. And so keeping those copies would be analogous to the copies that underlie the Google Books search index or any of those other search service indices. And I think the case is pretty straightforward that the logic of those cases applies directly to text and data mining. Now, one little difference is that journal publishers do claim or purport to offer text and data mining licenses. And so under that fourth factor of the effect of the use on the value or of the work, a publisher might argue that you're interfering with my ability to license text and data mining by claiming it's a fair use, and therefore it can't be a fair use because I have an existing license. But that is not always a winning argument. And if the use is transformative, then it shouldn't need a license because by nature of being transformative, it is a type of use unlikely to interfere with the copyright owner's economic interests. And I think that logic applies here. So those licenses that are purported to be offered by publishers may be licenses that you need outside of the United States. But inside the US, it's my argument that it's already a fair use. You don't need that license. And therefore, there's no reason to enter into that. However, many academic libraries in the US have entered into licensing agreements that trade away fair use. And the reason is because the publishers will only provide access to their corpus of material if those libraries sign away their users' rights. It's not just limits on bulk download, but it's how long the user can keep the data that really interferes with the scientific practice of text and data mining because the user under those licenses is supposed to destroy their research corpus after they've produced their results, which undermines reproducibility, which is already a big problem in science and made worse by this publisher practice. However, under US contract law, if you sign one of those agreements, that's an enforceable agreement. And courts have said you as an individual can trade away your free speech rights or your fair use rights by contract, and the court will enforce that contract. So one last question then is, does the analysis change if we ask whether a researcher in the United States can text and data mine the corpus of Sci-Hub, which is this large corpus of 65 million and counting science journal articles that are hosted, we're not quite sure where, and has been the subject of a number of lawsuits, including default judgments in the amount of $15 million here in the US. And I will say up front, yes, it's copyright infringement. Copying 60 plus million journal articles without a license is copyright infringement. But the question I want to ask is whether a text and data mining researcher can nonetheless make copies of that infringing material solely for the purpose of engaging in text and data mining research. And my argument is yes. And the reason is that the transformative use of producing text and data mining research justifies making the copies even if the source is an infringing copy. First, I have a conceptual argument that fair use is about the use of the work, which is an intangible work, and should not pay reference to the source of the copy of the work. However, there are courts that have said that fair use should also include an inquiry into the user's quote-unquote good faith, and if the user knows that the copy from which they are making their use is infringing, they are not acting in good faith. But there are some cases that think good faith counts, but have nonetheless found a fair use when the source of the copy was infringing, because the court did a cost-benefit analysis and found that the value of the secondary use was very strong and the impact of using the infringing copy was minimal and therefore should still go forward as a fair use. I first argue that good faith does not belong in the analysis, that fair use is a legal doctrine. And what I mean by that is it is limited to those set of rule or factors that I described above. And it should be a legal doctrine in the sense that it should be looking at the secondary use from the public's general interest in getting access to that use and not treating this as a more personal dispute between the author or the copyright owner and the individual user. It's really that public interest in getting access to fair uses of copyrighted works that fair use should be protecting. And if we take account of the individual defendant's access to the work and whether it's infringing or not, we undermine that public interest approach. And second, even if good faith is a factor, I think the researcher who engages in text and data mining of Sci-Hub is acting in good faith. Being able to actually compute on that corpus provides one of the best likelihoods that we're going to get some of the kinds of insights that text and data mining is trying to give us. And of course, in the time of pandemic, when we are seeking to understand and develop a vaccine, the White House has already called on publishers to make their materials all available for text and data mining precisely because of this potential. And the harm to the publishers from Sci-Hub comes from Sci-Hub, not from the text and data mining research of Sci-Hub. Now, of course, the researcher who copies that entire corpus would have to make sure they're not making that corpus available to the world themselves. That would be a very different case. But if they're merely keeping it as research data on their server, I think that's still a fair use. In the future, I can imagine that text and data mining research might be stored in the cloud, and you could actually stream the data to the server in the US. And if that's the model of processing, then the researcher could argue that no copies are actually being made at all in the US, and therefore US copyright law does not apply to that research. It's unlikely, talking to some of these researchers, they say, if we had to do it that way, we could. It is not optimal, and we would never design our research process that way unless the law made us. But I leave it out there as a sort of point to be taken that there is an alternative if, for some reason, fair use were to be taken away. And then in the interests of making sure the conception of this conference is respected and that we understand that there are concerns about text and data mining and not just benefits, my analysis was designed around copyright, how copyright would analyze text and data mining of published research, where the interests of the author is to make their work public and to advance the understanding in science. But I recognize that text and data mining as a technique, as a technology, or set of technologies implicates a series of other interests that the law should care about, such as privacy, national security, and also equitable access to the products of this research. And so there might be, my analysis does not in any way interfere with other bodies of law regulating text and data mining. And so it might be fair use from a copyright perspective, but still unlawful for a different reason. And for me, the poster child for this argument would be Clearview AI, presented to you as a computer vision for a safer world, but having a corpus of millions and millions of facial photographs taken from social media without anyone's consent, and then used to create facial recognition software that can be quite privacy invasive. And because the United States lacks the kind of robust privacy protection that we now see in the European Union, instead, the ACLU has had to file a lawsuit relying on an Illinois law, which creates biometric privacy, and arguing that the scope of that privacy law applies to Clearview AI. And I think it's a sad statement on the state of United States law that this is the best we can do in response to this use of text and data mining. So I would say, the intersection of my research and this concern is if one of the photographers whose photos were in that database were to bring a copyright infringement case against Clearview, my analysis would say that Clearview would win that copyright infringement suit, and I'll stand by that. But I think what Clearview is doing is a deep, deep concern. I agree with the reasons the ACLU are bringing this lawsuit, and I hope that we can get a better understanding about text and data mining and develop a more robust suite of legal tools that sort of cabins the use of this technology and protects those interests that deserve legal protection. And I look forward to talking with everyone in the live session. Thank you very much.